We're starting today with a situation that sounds like something out of a movie. A land fraud from 1996 involving owners who are already dead has just completely rewritten the rule book for every high court in India.
It really has. We're talking about the Anna Waman Bhalerao judgment from 2025, and on the surface, it looks like a simple property dispute.
But it's so much more. This is really about personal liberty, about a constitutional right to a speedy decision.
Exactly. It's this fascinating collision, between a 20-year-old fraud allegation and the fundamental rights of the accused. Supreme Court had to step in.
So let's get into the backstory here, what I've been calling the zombie land deal.
A good name for it. So back in 1996, you have these revenue officers, the people appealing in this case, who certified land sales.
Okay.
The problem was the power of attorney documents they certified were supposedly from owners who had been dead for years.
So they basically let the dead sign away their own property.
That's the allegation. And get this, the fraud was flagged way back in 1998, but the criminal case, the FIR, wasn't actually filed until 2019.
20 years later.
A 20-year gap. So these accused are now retired public servants who are suddenly facing arrest for something that happened decades ago.
So of course they'd move for anticipatory bail.
Immediately. That's Section 438 of the Criminal Procedure Code. It's asking the court for protection before the police can arrest you. A standard move.
Right. They went to the Bombay High Court in 2019. The court gave them interim protection.
Which just means the police can't arrest them while the court thinks about the main bail application. It's meant to be temporary. A few weeks, maybe a month at most.
But it wasn't a month.
No.
The High Court just sat on the application for 6 years.
6 years. From 2019 to 2025. The case was just listed and adjourned again and again. No final decision.
And that's what caught the Supreme Court's attention.
That's the trigger. Justices Partiwala and Mahadevan they were not happy. They argued that keeping an accused person in that kind of limbo is a direct violation of Article 21.
The right to personal liberty. They used that great metaphor, didn't they? The sword of Damocles.
Yeah. A perfect image for it, yeah. It describes that feeling of a threat. In this case, arrest, just hanging over your head by a single thread.
You can't live your life.
You can't. The court's point was that this interim protection isn't real freedom. You're just waiting for the sword to drop. They even reached all the way back to the Magna Carta.
I'm 1215.
To make the point. To no one will we deny or delay right or justice. A decision has to be made. You can grant the bail or deny it, but you can't just leave the file on a shelf.
Okay, so here's the twist. You'd think after all that the Supreme Court would grant them bail, acknowledge the violation, and let them go.
That's what you'd expect, but no, they didn't.
Why not?
The court drew a line between the procedural failure and the crime itself. They said, yes, the delay was unconstitutional, but the alleged fraud was just too serious.
These were public servants.
Exactly. Public servants allegedly helping to steal land. The court decided that custodial interrogation was necessary to try and find the forged documents.
So the need for evidence ultimately won out over the 6-year delay.
For these specific individuals, yes. Their appeal was dismissed. They have to surrender. But while they lost their personal fight, the judgment created this huge win for the entire system.
The 2-month rule.
Precisely. To stop this from ever happening again, the Supreme Court laid down a mandatory rule. All high courts in India must now decide bail applications within 2 months of filing.
That's a hard deadline. No more endless adjournments.
It kills the practice of granting interim protection and then, just letting the case fade away. Interim relief can't be a substitute for a final decision anymore.
For lawyers, this must feel like a new superpower.
It is. A lawyer can now walk into court and cite Anna Waman Bhalerao to demand a faster hearing. But it's also a warning.
That fraud has a long memory.
A very long one. And that interim protection is not a permanent shield. If you don't cooperate, you will face arrest.
But there's a practical problem here, isn't there? The high courts are already completely overwhelmed with cases.
Absolutely. It's the classic tension between doing things quickly and doing them right.
So here's the thought I want to leave everyone with. Is a strict 2-month deadline a true savior for liberty? Or could it crush an already overburdened system, forcing judges to rush to judgment just to meet a deadline?
Justice hurried is justice buried. It's a real danger.
It's something we'll have to watch very closely. Thanks for breaking this down with us. We'll catch you on the next deep dive.